part of the reason why I was called to the conference was because at the end of my presentation, all of you can feel happy that you are Malaysians. And that things are still not as bad as they are in the rest of the world. Alternatively, you can consider me as a hidden member of the National Security Council, because equally, some of the things that Ms. Srivasan talked about, the military, civilian fault lines and dictatorships, the fears that Malaysian civil society has about what can happen if it becomes the new normal in Malaysia, all of those things have actually happened in Pakistan. So we've lived under military rule for, I think, a good 25 years. But whatever it is, I think ultimately the important question for you, looking at a comparative perspective of Pakistan would be, Pakistan is a good example in this case because it tells you some of the things that should be done, but mostly what should not be done. And it seems that the Malaysian government, from whatever I've heard and whatever I've read in the past week or so, is following the path of what should not be done. Just to put things in perspective and looking at some of the numbers. Now, this is the death toll in Pakistan. Conservative figures are that approximately 60,000 people have lost their lives since 2003. The more liberal account says it's 80,000, 47,000 of which is civilian population. So this figure includes terrorists as well as military personnel who've been fighting against them. Pakistan is ranked 4th in the Global Terrorism Index after Iraq, Afghanistan, Nigeria. Malaysia was 49 on the same list. More secure than UK, USA and France and some other Western countries as well. Places targeted in Pakistan, I think any place that you can think of has been targeted. Recently, a year or so ago, a school was targeted. 145 kids were killed in that school. So churches, hospitals, mosques, residential houses, within residential communities, kilometers away from any commercial activity or army installations have been targeted as well. People targeted, I mean a former prime minister, incumbent governor of a province, army generals, human rights lawyers, and just 10 days ago in Quetta, approximately 70 lawyers were killed. Now, Quetta is a small town. Just to put things in perspective, I only personally knew 3 lawyers in Quetta, and 2 of them died in this last 10 days ago. An entire generation of lawyers have been lost, and the civil society was specifically targeted in that attack. The Balochistan Bar Association president was first shot down. His body was taken to the hospital. The suicide bomber waited for lawyers to gather there, and then he detonated his suicide when all the senior lawyers had come there. Political reasons, I mean, I won't go into detail, but really it all started after the Soviet invasion of Afghanistan, Saudi Arabia, and America fearing the spread of communism injected billions in Pakistan, and the jihadi narrative and proliferation and funding of madrasas, which was owned by the military ruler of that time as well, because he wanted to legitimize his own government and his own Islamization policy. Some of it we heard in the morning session as well, how Islam is also used as part of security setup. And then recently, after the US invasion of Afghanistan and Pakistan's support of the US-led coalition, so Pakistan took a U-turn sort of against these jihadis, and in 2006-07, the Pakistani Taliban were born and they declared an all-out war against Pakistan. So how has the legal community, dealt with some of these issues. Now, the Constitution of Pakistan is fairly decent when it comes to protecting civil liberties. You have all the rights that you can think of, civil and political. On top of that, something which Malaysia hasn't done, which makes me feel happy as a Pakistani. We are a party to the International Covenant on Civil and Political Rights, and the Supreme Court says that in interpreting fundamental rights within the Constitution, Pakistani courts have to look at, for instance, Article 14 of the ICCPR and some of the other relevant articles of the International Covenant as well. And some provincial legislation also defines human rights, not just as rights within the Pakistani Constitution, but also rights within ratified treaties and customary international law as well. So things are, pretty decent when you look at the law. Now, the security regime of Pakistan, the main act predates really the rise of 9/11, or as Bush and some of the other Bush doctrine leaders would want us to believe was the change of world, predates all of that. So the law was enacted because the tribes weren't speedy enough, so we needed a special court. So anti-terrorism court was created. As is the problem in Malaysia as well, the definition of terrorism was so broad, so vague, which I don't think is a problem of drafting of legislation. It's quite intentional because it happens all the time when it comes to defining some of the key terms. That I once tried a case in an anti-terrorism court which was a runaway marriage case. So typically runaway marriages, the family of the girl would file a criminal complaint of kidnapping because that protects their honor in the community, and that is one of the scheduled offences. There are a list of 30-40 offences which are part of scheduled offences, as a result of which the main purpose of the creation of this court was defeated. Which is why actual terrorism cases could not be successfully prosecuted in Pakistan. One famous case was the Marriott bombing case. At one time, it was the biggest hotel in Islamabad, and it's a hotel within a kilometer of all major government buildings, the presidency is there, National Assembly is there. There were 83 witnesses in that case. All of them resigned from their statements. So essentially the case resulted in an acquittal. Now, without dealing with any of those problems, and you can see that at one stage the conviction rate in anti-terrorism cases in KB is Khyber Pakhtunkhwa, the province which borders Afghanistan, so really the province at the forefront of the war on terror and terrorism cases, the conviction rate was almost 2%. So without dealing with any of these systemic problems, no effective witness protection, and a number of these problems, what we did was, what it seems that the Malaysian government is doing, one law after another. We came up with two laws, Protection of Pakistan Act and the Pakistan Army Amendment Act. And really, when we were attending discussions with government functionaries, some people we were lucky to know who were experts, lawyers who were hired as experts to draft these laws, we asked them a simple question: why do you need this law? What is it that the Anti-Terrorism Act or other laws cannot do, which you think you're going to achieve with this law? And there was never an answer. Now, in private gatherings, some of them would say that because Anti-Terrorism Act has already been interpreted by the Supreme Court, so our powers are curtailed. This new law will take us years to be in a position where we are right now. So new law essentially means that a lot of those terms are not interpreted. The government feels that it has unfettered powers to do whatever it pleases. And then, in the years to come, when the law is challenged and some of the definitions are watered down, the government then probably thinks about other things as well. But I'm sure there are other reasons why governments think that new laws are the answer. So the preamble of COPA is very similar to the preamble of some of the other laws from elsewhere as well. Again, it's replete with broad and vague terms. We don't know what national security is. We don't know what national interest is. There are powers of shoot to kill. In Pakistan, I don't think, the distinction or the separation of international humanitarian law and human rights law is a problem in Malaysia. But in some parts of Pakistan, we legitimately ask the question of which international regime applies. Because the government was in war with the Taliban, who actually had control over some cities in Pakistan as well. So there was no answer to any of these questions. Similarly, preventive detention, I was reading in a paper as well, lawful, but it often leads to other violations which are not allowed, which are non-derogable, such as torture, confessions, extrajudicial killings. And with the lack of transparency with these special regions under the National Security Act of Malaysia, some of these things are going to happen. I also heard from the last speaker that there seems to be a problem with burden of proof as well in the schedule that was read. So if there's any material that you have, the burden suddenly shifts on the accused. So that becomes really problematic if you're defending these provisions. And then, the exclusion of main provisions from the law. Similarly, the military courts took over a lot of civilian cases in Pakistan, a couple of years ago. As a result of which, the military courts, and I suspect that will happen in Malaysia as well. So there will be a really good publicity of the National Security Act and some of the things that happen under the National Security Act. And at the same time, the civilian courts will be demoralized, and there will be an effort by the government to show and justify why this act was needed in the first place. A lot of that happened in Pakistan. So the government actively engaged in media campaign to undermine civilian courts and some of the other laws that were there. So the net outcome is that the civilian courts are demoralized, and the military courts and some of these special regulations are seen as saviors by the people. So essentially, what really are the questions? Now, probably the most crucial question, and I think this question was addressed in the first session as well. We can skip the second one, but the first one and the third one I think are important for Malaysians going forward. What's the place of civil liberties in the trade-off with security? And really, it's a question that's easier asked than answered. Now, how do you balance rights with security? Security being a fundamental right as well. Often it's a right to life issue. And then thirdly, deciding which measures are sustainable. Because don't mistake this fact that some of the things that the government is doing today to deal with extraordinary situation is going to become a normal for you if things do not change. And 5 years from now, 10 years from now, you would not have realized, but the Malaysian society and the nature of Malaysian law would have changed, and it will become the new normal for you, as we have seen things happening in the last 10, 12 years in Pakistan and before that as well. One of the ways in which you can balance rights, and Malaysia is not a party to the International Covenant on Civil and Political Rights, is by distinguishing derogable and non-derogable rights. So for instance, UK is a good example. Post 9/11, UK lawfully derogated from the International Covenant and said that, well, essentially there are certain rights which we cannot give to the people for this period of time, and these are those rights, but there are other rights which are non-derogable rights which cannot be taken away no matter what the situation is. And reading some parts of the Malaysian Constitution, it seems that the Malaysian Constitution already envisages an emergency situation. So if it already envisages an emergency situation in 150, we really don't understand why this new legal regime or this new body is required. But like I said, it's a very difficult question of how do you balance civil liberties with your security. We'll skip through some of these slides. but you can have a look. It's really relevant to Pakistan. Hopefully, it will never be relevant for Malaysia. So, what mayors are not sustainable? Now, some of these things have become part of our normal in the last decade or so. So, for instance, every new law that is drafted now has a burden of proof shift on the accused. And gradually it seems, now the thing with these laws is that they're very effective. So in the short term, empowering the government with unfettered powers and granting them laws, ambiguous laws, actually provides you the answer to terrorism in the short term. So the judges get used to it, the government gets used to it, as a result of which the systemic problems will remain. So burden of proof, I mean, Pakistani police forces have never been known for their investigative skills. So torture and shift of burden of proof is like a Christmas present for them. The only thing is that they will never learn how to investigate cases, and they will never learn how to interrogate without torture. And this is a problem that USA also faced post 9/11 when it came to gathering information from foreign nationals. Now, obviously, the federal FBI and other police agencies in USA do not have the same access to Afghanistan or areas of Pakistan where some of these terrorist activities are hatched. So even professors from Harvard University, one Professor Ellen Dershowitz talked about torture warrants. He said torture is now inevitable post 9/11, so let's have torture warrants. Now some of those things have changed, but the key to investigation still remains proper investigating legal skills. So, the Pakistani police now probably is never going to learn how to investigate a case properly because they now can torture, not legally, but because it's become part of the law. And similarly with burden of proof, I don't think these are sustainable measures. They will seep into the law and become the new normal. What measures are not sustainable? Extrajudicial measures, killings, detentions. Clearly, they can never be allowed. It seems that the National Security Council has some of that as well. A very good example of that, I think, is a European court case where a police officer, it seems that there is a deficiency with the drafting of the law, because if a police officer on duty decides that force has to be used, he can use that force, but what's the oversight and what's the planning that takes place in making that decision? So it will be run by complainants, and they have the power to reconcile those cases with the accused as well under Islamic provisions, although the court in Pakistan still remains secular, but there is an emergence of secular and Islamic law, as a result of which even normal criminal cases are now privately owned by individuals. So state has a very limited role in criminal cases, which cannot happen in anti-terrorism cases. So I think as a result, anti-terrorism cases have not been successfully prosecuted in Pakistan as well. So I think really the key question for Malaysia, and I say that not to trivialize the threat that Malaysia faces, but as a complement to the vibrancy of the civil society and the fact that probably Malaysia is not as fertile a ground for terrorists as it is, or as Pakistan is right now, or has been historically as a result of the Soviet invasion. I don't think Malaysia is probably at the point where it has to make the kind of hard choices with which Pakistan has made. I mean, we now have to decide whether we live in a Pakistan where there is an occasional bomb blast, but we have our civil liberties, or we live in Pakistan which is completely terror-free, but we don't have the civil liberties that we want to enjoy our lives. And I think that as human rights advocates, as civil society, we decided that we want to live in Pakistan where we can live with an occasional terror attack, but what we can't forgo is is our civil liberties. I think Malaysia will have to make that choice in the years to come, but probably not right now. And I think that is the right choice. Thank you.